In this lesson, we're going to go over the unprotected categories of speech referred to as fighting words and true threats. So big picture, if we're looking at a constitutional law fact pattern and we see the government is coming along and the government is trying to regulate speech because the content of the speech deals with anything along the lines of insulting language, threatening language, abusive language, hateful language. In any of these cases, we have to think, okay, does this speech being regulated by the government constitute an unprotected speech category like fighting words or true threats? Because we know big picture, if the government is regulating speech based on the content of the speech, and the content of the speech is protected under the First Amendment, in most cases the government will not prevail, right? We're going to apply strict scrutiny to that statute. Remember, in order for the government to get past the burden of proof required for strict scrutiny, the government has to have so much justification, such a high level of justification. It's exceedingly rare that the government's going to be able to provide the amount of justification needed to get past the standard of review of strict scrutiny, that the regulation is going to be struck down in violation of the free speech clause of the First Amendment. Okay, and that's when we have a content-based speech regulation of speech that is protected. The content of the speech being regulated is protected under the free speech clause of the First Amendment. That's when we apply strict scrutiny, and in most of those cases, the government does not prevail. However, remember, we have this major exception, these unprotected categories of speech, where we say actually in these cases, the government can come along and they can regulate speech based on the content of the speech if the content being regulated falls under these unprotected categories of speech. In our last lesson, we talked about inciting imminent lawless action. In this lesson, we're moving on to fighting words and true threats. So that's why it's always our question. When we see a content-based speech regulation, kind of our big question is, okay, is the content of this speech that's being regulated by the government, does this content fall under an unprotected category of speech, or is it a protected category of speech? And our default is most speech is protected by the First Amendment. Just over time, the Supreme Court has basically carved out these unprotected categories. Again, in our last lesson, we talked about our first one, inciting imminent lawless action. In this lesson, we're focusing on fighting words and true threats. Okay? And when we're thinking about fighting words and true threats, from a big picture, this kind of looks like when the government is trying to regulate speech because the content of the speech deals with like insulting language, it deals with personally abusive language, it deals with hateful language, or it deals with like threatening language. That's kind of when we're in this zone, this territory of fighting words and true threats. And we kind of have to go through these analyses to determine, well, is the speech being regulated here? Does it actually constitute fighting words or true threats? Because if it does, okay, those are unprotected categories of speech. Generally, the government can come in and regulate speech in those areas because unprotected speech is like outside the scope of the free speech clause of the First Amendment. So generally, the government's going to be able to come in and regulate in those areas. So that's why we'll want to determine whether the speech being regulated actually does constitute fighting words or true threats. So how do we do this? How do we determine whether speech being regulated by the government constitutes an unprotected category of speech like fighting words or true threats? Well, for fighting words, we start with the Supreme Court decision in CHAPLINSKY v. New Hampshire. Pursuant to this decision in CHAPLINSKY v. New Hampshire, the government may restrict speech that constitutes fighting words. Again, the Supreme Court is classifying this as an unprotected category of speech, basically outside the scope of the free speech clause of the First Amendment. In CHAPLINSKY, the Supreme Court defined fighting words as words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. In other words, the definition I would recommend using if we're on a constitutional law essay or we're just in a constitutional law analysis, I would say the government may restrict speech that is personally abusive such that the speech is likely to incite immediate physical retaliation in an average person of ordinary sensibilities. This definition really kind of encompasses all the things we're looking for from this CHAPLINSKY Supreme Court decision. So, from a macro, big picture perspective first, when we're thinking about fighting words, one of the first things I kind of think about in my head when I'm looking at a fact pattern and I'm wondering whether, because typically the way this plays out is somebody says something offensive, and it's like, is this offensive enough basically to actually be considered the unprotected category of speech that is fighting words? And one of the things I kind of think about in my head, and this isn't like something you write on your essay as a part of your legal analysis. I just call this the would you get punched in the face test, right? Imagine that you take this statement. So your fact pattern is going to give you some statement that was uttered to somebody and it made that person really mad, right? And you're trying to decide, is this statement fighting words? Imagine if you went up to a person of average, an average person, a reasonable person of ordinary sensibilities. You walk up to this person and you repeat this statement to that person. Is it likely that you would get punched in the face for saying this to an average person of ordinary sensibilities? Like if you just walked up to someone and you said this thing to an average person, would you get punched in the face? If the answer is it likely you would get punched in the face, if it is likely that you would get punched in the face for saying this to an average person of ordinary sensibilities, it's probably fighting words, If it's not, if the answer is, well, probably not, it's not really likely I would get punched in the face for saying this to an average person of ordinary sensibilities, then it's probably not fighting words. Because if we think about this definition, it's all about personally abusive speech that is likely to incite immediate physical retaliation in an average person of ordinary sensibilities. So we're looking for that type of language where if you said this to a person, you'd basically just get punched right there on the spot. It's going to rouse them right there. It's so egregious. There's so much vitriol in the statement. There's so much hatred, vitriol, perversion, malice, whatever it is in that statement that you're actually going to incite immediate physical retaliation in an average person. Key is it's an objective test. So of course if you're dealing with a fact pattern where a person subjectively has some unique, really special sensibility that might make them more prone to being violent, that's not a part of the analysis. That's kind of irrelevant. It is an objective test. We're asking objectively, what are things that would make a reasonable person likely to just retaliate physically in an immediate response to being told something, okay? And so if we look at the case law, the themes that I would say I see kind of come up again and again. What are the things objectively that most reasonable people of ordinary sensibilities, what are touchy subjects for reasonable people? And these are kind of the themes I see pop up again and again in kind of our fighting words series of cases. And I would say kind of the things that if you touch on, would be things that even reasonable people are going to have, a very kind of physical reaction to when we're thinking about, what is likely to incite an immediate physical retaliation in an average person. I would say anytime, based on the case law, race, religion, politics, or family is involved. If you have race, religion, politics, or family. Somebody comes up and they say something very hateful, very derogatory, very repugnant about, somebody's race, and they use it in a personally abusive way directly to that person, that's something that could be likely to incite immediate physical retaliation in an average person. It's a sensitive subject. When you go up and you start bringing race into something and you do it in a really derogatory, abusive way directly to a person, that's where it can be likely to incite immediate physical retaliation. Same thing with like religion, politics, family. You talk about somebody's child, somebody's spouse in a really derogatory, insulting way that's meant to be really personally abusive. A lot of times we see that's the type of speech that can be likely to incite immediate physical retaliation in an average person of ordinary sensibilities. Now, it's important to remember when we're thinking about, speaking negatively about things like race, religion, politics, and family, generally, from a big picture, you're allowed to be, insulting to race, religion, politics, family, all you want. Like, this is protected speech. This is why, a great example of this is the musical on Broadway called The Book of Mormon. Over the last decade, like the most commercially successful musical on Broadway in New York City has been a musical called The Book of Mormon. And I haven't personally seen this musical. I'm not a huge musical guy, but from my understanding, it's basically 2.5 hours of just making fun of the Mormon religion. Just 2.5 hours of criticizing, of, lambasting this one particular religion. So I imagine a lot of people that are of the Mormon faith probably find this pretty offensive, even insulting. But in that case, it's protected speech under the First Amendment. You can have a musical that for 2.5 hours just insults a religion. That's protected speech under the First Amendment. That's not the type of speech that's likely to incite immediate physical retaliation in an average person of ordinary sensibilities. And there's several reasons for this. Number one, the Book of Mormon, like a musical, very obviously that is satire. It's political hyperbole. And satire and political hyperbole, we're going to talk about some cases there later in this lesson, but that's generally protected. A reasonable person, average people of ordinary sensibilities, can understand what satire is. It's a joke. It's not serious. It's not something to get violent over, right? So that's one reason. Another reason, just from a big picture to think about, anytime we're thinking about musicals, film, TV shows, these things actually have some, if not a lot, societal value. When we think about our unprotected categories of speech, from a big picture, the reason that the Supreme Court is carving out unprotected categories of speech is because the Supreme Court is basically saying the societal value of this speech is very low and the risk of harm to people is very high. And so because the speech value is really low and the risk of harm is really high, these are unprotected areas. The government should be able to come in and prohibit those things. When we think about inciting imminent lawless action, fighting words, true threats, obscenity, defamation, all of these things don't have like a lot of societal value. When we think about free speech, the main purpose of the free speech clause of the First Amendment is to protect expression of ideas. Things like fighting words and true threats, obscenity, like the value of those ideas and the expression of them is really low in comparison to like the risk of harm. So that's why the Supreme Court comes along and says, hey, these are unprotected, the government can restrict them. We think about like a musical like the Book of Mormon, there's actually objectively a lot of artistic value there. You probably couldn't have one of the most commercially successful musicals on such a reputable stage like Broadway in New York City if there wasn't some artistic value. So even if it's insulting to a lot of people, the performers, the music, a lot of that's all going to be world class. To get to that stage, literally Broadway in New York, and a major commercial hit, Like the performers, the music, the dancing, all of that stuff is going to be like world class. There's a lot of artistic value basically. And when we think about unprotected categories of speech, we're typically thinking about things that have really low speech value. So for all of these reasons, right, that's why the Book of Mormon is protected. But the reason, you know, from the CHAPLINSKY decision that it's not fighting words and kind of Cohen v. California, which we'll talk about in a second, is because it's not personally abusive. Like that musical is not personally abusive to a specific person enough that it's likely to incite immediate physical retaliation in an average person of ordinary sensibilities. Average person's gonna understand what satire is. Okay, it's a joke. It's not something to actually physically retaliate over. Another good thing to point out here when we're thinking about the Book of Mormon and like a musical and why it's not fighting words is Cohen v. California. Cohen v. California, I think, establishes a really important rule when we're thinking about fighting words. Really, the takeaway from Cohen v. California is we have to, in order for language, for words to constitute fighting words, we have to see those words directed at a specific individual. In Cohen v. California, we have a person who's basically wearing a jacket that says F the draft, right? But it doesn't say F, it says the 4-letter F word, and it's basically like a protest. This is from 1971, a protest of the Vietnam War. Like, you know, I'm not a fan of the draft, F the draft. And so of course this gets worn around and it makes some people upset, and ultimately, in that case, our defendant is charged with some sort of low-level ordinance for like breaching the peace. And this actually gets all the way up to the Supreme Court, even though it's a really small kind of misdemeanor violation. It gets all the way up to the Supreme Court, and the Supreme Court says, look, that's protected speech. You can wear a shirt or a jacket that's got some political message on it that might be offensive to certain people. That's protected under the First Amendment. That's not a fighting word, you know, and really their major reasoning there is for something to be fighting words, when you really think about it, it's got to be something that's really directed at a specific person. You know, it can't really be personally abusive such that it's likely to incite immediate physical retaliation in an average person of ordinary sensibilities, unless it's like directed right at someone. You know, when you think about a musical being performed, you know, that's not really, that's kind of like Cohen. You know, that's more like wearing a jacket. It's not really directed at a specific individual. So when you think about Cohen and everything else we talked about, that's why the Book of Mormon is not going to be considered fighting words. And that's the reason why TV shows, books, movies, music, all those forms of art and media expressions, right? Generally, it's not going to constitute fighting words because it's not directed at a specific person. That's Cohen v. California. And it's important to recognize that's why in the United States, we don't have, like in other countries, very general, broad, like hate speech laws. You know, people are allowed to get up and say very disfavorable things, very insulting things about race, religion, politics, family. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone! everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first-year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.